Chapter 3: Medical, Legal, and Ethical Issues. It's important to understand the medical, legal, and ethical issues pertinent to the EMT. As you approach patient care relating to things such as confidentiality, consent to treat, refusal of care, and advance directives. Organ donor systems and policies, evidence preservation, and end-of-life issues are also discussed throughout this chapter. There are several competencies that the EMT needs to be familiar with for this particular chapter. The number one golden rule to live by in EMS is first, do no harm. If the patient is worse for wear after we're there, did we really do our job as an EMT? A healthcare provider usually avoids legal exposure if he or she acts in good faith and according to the appropriate standard of care. The EMT is the first link in the chain of pre-hospital care of survival. EMTs become an important component of every aspect in the pre-hospital environment. However, it's important that EMTs know the legalities and their standard protocols and treatment aspects that they should be following, treatment guidelines, to avoid civil and criminal actions. Even though oftentimes the EMT has the best interest at heart, there are times that patients may be seeking monetary compensation despite the EMT's best efforts. Consent is permission to render care. A person must give consent for treatment. If the patient is conscious and rational, he or she has a legal right to refuse care, just as you had seen in your last case study. The foundation of consent is a decision-making capacity, meaning that the patient has to have the ability to make their own decisions, that they can understand the information that you're providing to them and make the informed choice regarding their own medical care. If the patient's having trouble understanding what diabetic ketoacidosis is, that you explain to them in terms that they understand so that they are properly informed to make the right medical decision. Every patient that is conscious and rational has their own autonomy. Autonomy is basically that patient's right to make their own decisions about his or her health. In determining that patient's decision-making capacity, you need to consider these factors. Is the patient's intellectual capacity impaired by either mental limitations or dementia? Are they of the legal age of 18? Is the patient impaired by alcohol, drugs, or serious injury or illness that's preventing them from making a smart decision? Does the patient appear to be experiencing significant pain? Does the patient have a significant injury that could distract him or her from a more serious injury? Are there any apparent hearing or visual problems or communication barriers that exist? And does the patient appear to understand what you are saying? If the patient doesn't understand what you're saying, is there a better way to explain it to that patient or someone that can interpret the information for you? Implied consent applies to patients who are unconscious. These patients are otherwise incapable of making their own decisions. Implied consent only applies when a serious medical condition exists and should never be used unless there is a threat to the life or to the limb. The principle of implied consent is known as the emergency doctrine. This sometimes represents a serious threat that is unclear and may become a legal question later on. It's a good idea to try to get a consent from a spouse or relative before treating a patient based on implied consent alone. Involuntary consent applies to patients who are either mentally ill, have a behavioral problem, or show signs of developmental delay. It's important that you try to obtain consent from their guardians or conservator in those particular situations. However, that may not always be possible, so you need to understand what your local provisions are. For example, a lot of states have protective custody statuses that allow such a person to be taken under law enforcement authority to a medical facility. Children require a parent or legal guardian to give consent. However, if the parent or legal guardian isn't present and the child is in a serious or grave condition, those children are treated under implied consent. In some states, a minor can actually give consent themselves depending on age and maturity. Some minors can also become emancipated. An emancipated minor is a person who is under the legal age in a given state, but because of other circumstances is now legally considered an adult. In some states, this is if a minor When dealing with the child, if a true emergency exists and no consent is available, treat the patient. Your consent is implied. Never withhold life-saving care from a minor because a parent or authorized guardian is not available to sign. Sometimes we're required to apply forcible restraint. This might be necessary with a patient who is in need of medical treatment and transportation, but is combative and presents a significant risk of danger to himself or others. Sometimes forcible restraint is considered permissible. You can get permission from medical control or authorization from medical control, and in some states, a law enforcement officer may forcibly restrain your individual or patient. Just make sure if they handcuff the patient to the stretcher that an officer goes with you or directly behind you to allow for removal of the cuffs, because if they don't have a cuff key with them and you have to start doing CPR on your patient, it delays patient care and transitioning your patient over. So make sure there's always an officer with a cuff key to unrestrain your patient. If forcible restraint is utilized, it's essential to protect the patient's airway and monitor the patient's respiratory status to avoid asphyxia, aspiration, and many other complications that can arise from restraining a patient. Know your local laws and be aware of what your state protocol and guideline is for restraining patients against their will. Adults who are conscious, alert, and appear to have decision-making capacity have the right to refuse treatment, even if the result is death or serious injury, as long as they understand the risks involved of signing the refusal and refusing treatment. They can withdraw from treatment at any point in time. So even after you initiate administration of a medication and then they decide that they no longer want to go by ambulance, that's their right to refuse your treatment. So you need to make sure that you contact medical command and thoroughly document and get a refusal of care at that point in time. A lot of times these patients are going to present the EMT with a huge dilemma, because the EMT is going to question whether or not they should leave the patient alone or whether the patient should even be refusing treatment to begin with. Calls involving refusal of treatment are commonly litigated in EMS and require you to proceed very cautiously. Most medics and EMTs will tell you that after you get a patient to sign a refusal, you're responsible for that patient for up to 72 hours. So if something happens to that patient that's related to the refusal within 72 hours, that you could potentially be held liable. That's one of the reasons that these are often litigated. You have to be familiar with common practices and policies. If your dispatch center has a recorded line, have the patient read the refusal rights over the phone on a recorded line and have them verbally giving the refusal to someone else that can witness if it's only you and your partner. If a law enforcement officer is there, then have them witness the document as well. And when I say witness, I mean actually obtain their signature on a piece of paper. If dispatch isn't available or your dispatch doesn't have a recorded line, then contact Regional Command or Medbase. Their lines are all recorded. You need to assess the patient's ability to make an informed decision, so you have to ask and repeat questions. Assess the patient's answers that they're appropriate for the question and observe the patient's behavior. If the patient appears confused or delusional, you cannot assume that the decision to refuse is an informed refusal. It's really important when obtaining a refusal that you document. You need to document your assessment of what was potentially wrong with the patient, a description of the treatment that you felt was necessary for that particular patient, any possible risks of not receiving the treatment, any availability of alternative treatments other than transport to the hospital, and the possible circumstances or consequences of refusing treatment and transport at that particular time. The more you document, the better off you are. It's also good to have a recording of that person refusing treatment and transport. However, again, your safety is number one. If the patient becomes agitated and the more questions you're asking them or the more things that you're having them sign, it just keeps getting worse and worse and they start breaking beer bottles or some craziness like that, then you just need to leave the scene. Suicidal patients should not be regarded as having normal mental capacity. If they're suicidal and they don't care about their own safety, remember, they don't care about your safety either. So be very aware of your surroundings. Make sure that you don't let the patient stand between you and your exit. Patients who have attempted suicide or conveyed the suicidal intent are not mentally capable of signing the refusal on their own. When in doubt, providing treatment is much more defensible in a position than it is failing to treat a patient. You need to get law enforcement involved. Now, if law enforcement, regional command have all been informed and they're saying just let him sign the refusal and go on about his business, then you've done everything possible in your power to get that patient to the right treatment. Again, the most important thing to remember is do not endanger yourself or your partner, and use the assistance of law enforcement to ensure your safety if needed. Before you leave a scene where a patient, parent, or caregiver has refused care, make sure that you are very encouraging again and again to allow care to be provided if needed. Make sure that they know that just because they called 911 and refused care this time doesn't mean that they can't call 911 and you come back and provide the service. Ask the individual to sign a refusal of care form and make sure a witness is signing the refusal form as well. Make sure that you're documenting all refusals and make sure that you get a baseline set of vitals if available. It's important to note that the patient had an alert and oriented mentation in your refusal, because if they're confused and you give them a confused altered mentation status as a GCS, then your patient basically has signed a refusal under duress, under confusion, and didn't understand what he was doing, and then you could potentially be held liable in court. So make sure that you document appropriately. So we've talked a lot about HIPAA, and I'm sure you learned a lot about HIPAA when you initially started at JanCare, but we're going to go through it in a little bit more detail. HIPAA stands for the Health Insurance Portability and Accountability Act of 1996. This contains a section on patient privacy. Information should remain confidential between you and the patient. In most states, records can only be released if the patient signs, if a legal subpoena is presented, and if they are needed by billing personnel to bill insurance, but for no other healthcare reasons at all, other than shared information between the hospital and the ambulance provider. Confidential information includes their history, assessment findings, what treatment you provided, and their demographic information. If you inappropriately release information, you may be liable for breach of confidentiality, which is the disclosure of information without proper authorization. The HIPAA Act of 1996 basically is a cross-section on patient privacy that strengthens privacy laws and safeguards patient confidentiality. Basically, it's a guidance on which type of information is protected. It ensures that healthcare providers are regarding that protection and lets the healthcare providers know that there's penalties for breaching that protection. Failure to abide by the provisions of HIPAA laws can result in civil and/or criminal action. Other names for advance directives include living will and healthcare directives. DNR orders must meet the following requirements. They have to state what the patient's medical problem is. They have to have a signature of the patient or legal guardian and a physician's signature as well. Most importantly, it can't have an expiration date on the DNR order itself. So usually these are orange in color or bright neon yellow and say "Do not resuscitate" orders on there. Here's a good example of a pre-hospital medical care directive, or DNR form. So basically it says, in the event of cardiac or respiratory arrest, I refuse any resuscitation measures. Basically this will have a photo or a sticker on the card with a date, and it has a signature of the physician and a signature of the legal guardian as well. Usually you'll find these on terminally ill patients taped on the wall or somewhere that's readily available so that families honor their loved ones' wishes. Advance directives are basically physicians' orders for life-sustaining treatment. They explicitly describe acceptable interventions that the patient has requested prior to getting this ill or this injured. It must be signed by an authorized medical provider. If you have any questions at all, given an advance directive, living will, or DNR order, make sure that you contact medical control for guidance. Some patients may have named surrogates. These surrogates are going to make decisions. They're going to have their durable power of attorney. They're also known as healthcare proxies. Due to the growing number of hospice and home health programs, you very well may find yourself in a situation where you're dealing with a healthcare proxy or dual power of attorney. Make sure that you honor these advance directives. Just remember, a DNR order doesn't mean do not treat. It just means don't resuscitate. Sometimes the orders specifically say do not place an advanced airway, do not provide chest compressions, but it doesn't mean that the patient doesn't want oxygen or doesn't want to receive antibiotics at the hospital or get IV fluids if needed. So just remember, do not resuscitate does not mean do not treat. Even in the presence of a DNR, you're still obligated to provide supportive measures such as oxygen, pain relief, and comfort. As an EMT, there are going to be times that you may have to determine if a patient has died. The determination of the cause of death is the medical examiner's responsibility, or the responsibility of a physician. The cause of death is not your responsibility. In the absence of a physician, we must obtain physician orders. If the body is still warm and intact, initiate emergency medical treatment. If the body's cold to the touch or stiff, that means rigor mortis has set in, and starting CPR or anything would probably be in vain at that point in time. Now, one thing to take into account and remember, if it's cold outside and the patient's hypothermic, the patient isn't dead until they're warm and dead. So again, the patient isn't dead until they're warm and dead. So if they're found outside in 2 feet of snow and haven't been seen in 3 days and their body's stiff as a board, you're going to continue working that patient until the patient's body temperature is back to room temperature. When you walk in and the patient shows no signs of life, they're not breathing, they have absent eye movement, there's no systolic blood pressure, there's no tendon or corneal reflexes, and there's profound cyanosis, it's a pretty obvious sign of death. Usually rigor mortis will set up first in the jaw, so the patient, you won't be able to open their mouth to look in their airway. Whenever you try to position some patients and their body is completely stiff, those patients have been dead at least 4 hours. Rigor mortis is considered a definitive sign of death. On this particular picture, you can see the palm print that a person touched the patient. That's what we call lividity and pooling. Okay, the blood has actually come out of the vessels and seeped into the interstitial spaces of the tissue, and that's what you're seeing, that blood pooling. That's a definitive sign of death. Another definitive sign of death, let's say you respond to a car accident and the patient has been decapitated. There's no resuscitation measures you can take that's going to save the patient's life. Sometimes there's what we call internal decapitations, and that's a little bit of less of a definitive sign. Just remember, as a general rule of thumb, if your patient is warm, you're going to work them. Putrefaction, or decomposition of body tissues, which, depending on temperature condition, occurs between 40 and 96 hours after death. Usually these patients will actually start to have quite the odor to them, so you're probably going to want to put a mask on. The trick is to put a little Vicks salve in the mask, little Vicks cream, and keep it in your pocket, so that way if you end up on a scene with a stinky patient or a dead body that smells terrible, you can put a little Vicks salve in your mask on, and you'll be a lot better than your peers, trust me. If any of you are as obsessed with the idea channel as I am, we get to play medical examiner to an extent. If we come in and the scene looks suspicious, for example, if we come in and it's a 30-year-old man who has profuse bleeding noted from his head, and he's got bruising on his knuckles, and he's bleeding from his knuckles, he's got scratches all over him, and the scene just looks odd after a forcible entry or something like that, clearly there's something else going on there. You need to get law enforcement to the scene and get a medical examiner to come to the scene. Now, I will tell you guys, in West Virginia, getting medical examiners can be kind of complicated. You do call the state ME's office, and then the state medical examiner's office will send you the appropriate person who's closest to you. A lot of times in Raleigh County, our closest person is coming from Greenbrier County, so it's at least an hour waiting on the medical examiner at the scene. If law enforcement's at the scene and has secured the scene, then you do not have to stay there with the body. If you've gotten cease effort orders, then you can go ahead and clear up and have them call dispatch once the medical examiner finishes the case. Sometimes law enforcement may have you stay there, depending on your involvement in the case. A patient who is dead on arrival, sometimes called DOA or DOS, is been basically found dead, and they don't really know what happened at that point in time or what led to their death because it wasn't witnessed. A death without previous medical care, or when the physician is unable to state the cause of death, is actually an ME case. If a patient commits suicide, the ME needs to be involved. Any kind of violent death that was unexpected or unexplained, you need to contact the medical examiner's office. If a patient has made the complaint in the past that they were potentially being poisoned, and that you've picked up that patient before and they told you that their significant other was poisoning them and now they're laying here in a puddle of vomit, you should probably get the medical examiner involved. So you do get do a little investigating here on your own. The medical examiners have to be notified if there's a vehicle that was involved in a fatality car wreck, or if there was a suspicion of a criminal act. Any kind of infant or child-related deaths, the medical examiner has to be involved. You should make every attempt to limit the disturbance of any scene involving the death where a medical examiner is going to be responding to the scene. If emergency medical care has been provided or been initiated, you need to make sure you keep thorough notes of what you saw when you came into the room and what was done or found. So you guys kind of get the feeling here, or you're kind of getting the realization that your documentation is super important. So the way that you document is going to become really important throughout your EMT and your EMS career. So there's some special situations that you need to consider. Organ donors have expressed a wish to donate their organs. Their consent is based on the donor indicator on their driver's license. It's important to note here too, one of the false misconceptions is that EMS providers base their treatment off of the organ donation card or the donation picture on their driver's license. That's not true. I can't tell you I've never picked up a driver's license and been like, oh, well, we'll go ahead and intubate him because he's an organ donor and his organs can probably go to that kid in, over in Missouri. I've never thought like that. I've never even thought to pick up a driver's license until after I'm at the hospital already. Your priority and your primary priority is to save the patient's life. In West Virginia, we don't have the organ tissue donor card. We have an annotation on our driver's license, usually in the left-hand corner of your picture. Make sure that when patients are in accidents and they're unconscious and they're really not able to speak to you, that you're doing a good assessment on these patients. By doing a good assessment, that means you have to physically put your hands on the patient. You can't do an assessment if you're not touching your patient. While you're doing your assessment, I want you guys to start looking for bracelets, necklaces, keychains, wallets, any kind of, even on a smartphone, they'll have a little emergency icon on their phone a lot of times that tells you what their history is. These bracelets, necklaces, keychains, wallets, and those sort of things will have indicators of what the patient's past medical history is if they have a substantial history. So they'll have a little medical alert bracelet. And if you text a certain number, you'll get the patient's history. Or if you input this code into the computer, you'll get a printout of their med list and that sort of thing. So there's actually been a lot of advancements with those applications. So make sure that you're checking their phones, you're checking their wallets, and you're using your bystanders that's available to you to get as much information as you can about a patient. Because a lot of times, guys, there's not going to be any family available and the patient might be unconscious, unresponsive. This is a great example of a medical alert bracelet. It's got a phone number on there that you can call. And basically, this advises EMS that the patient wishes to not be resuscitated. This medical alert bracelet is the patient's wishes, so we would honor this. So you'd have to call medical command and tell them, I was initiating CPR when I found this medical alert bracelet that says do not resuscitate, and then get the physician's orders to stop the resuscitation process. Everything that we decide as far as DNR orders go, that's the do not resuscitate orders, come directly from the medical command physician on call. So just because you're dispatched for a DOA doesn't mean the patient's been pronounced dead. You have to do that as the EMT. So if they're real dead, and you come in, you don't need a medic to come and do that for you. If they're showing signs of rigor mortis, lividity, and pooling, then you call med base and tell them what you got and get the orders from the physician not to work. Just make sure that you document the name of the physician and the time the order was given. Make sure you stay in your scope of practice. Your scope of practice outlines the care that you're able to provide. It's usually defined by state law, but more specifically, JanCare medical directors also play a role in what your guidelines are too. In West Virginia, we follow protocols and standing orders. But Dr. Staggers has to be willing to put her name on your card. A lot of times, Dr. Staggers works at the local facility, so if you come in doing craziness, don't be surprised if she doesn't want to put her name behind your card. So you wouldn't be able to practice at JanCare anymore because she wouldn't be willing to be your medical director. Even though you've been trained on how to do something doesn't mean that you should do it. You have to stay in your scope. Carrying out procedures that it's beyond your scope of practice will be considered negligent and could very well be a criminal offense and punishable according to the full extent of the law. The standard of care is the manner in which you must behave or you must act. You must be concerned about the safety and welfare of others. If you're doing this job and you hate people, you're probably in the wrong line of work. The standards of care are established by local custom and law. In our area, it's common practice to call patients sweetie. However, in Missouri, it is not common practice to call a patient sweetie, and it's very offensive there. So you're going to find local custom plays a huge role in what your standard of care is. As an EMT, you have what's called a duty to act. It's your responsibility to provide patient care. Responsibility comes from either statute or function. A bystander is under no obligation to assist a stranger in distress. They have no duty to act. However, once your ambulance responds to a call or treatment is initiated, you have a legal duty to act. In most cases, if you're off duty and come upon a crash, you're not legally obligated to stop and assist the patient. However, if you're displaying EMS tags or you have EMS EMT stickers all over your vehicle, you could be held liable for not stopping because you failed to have that duty to act. There may be some circumstances where this is not true, so you should be familiar with the laws in your area. If you choose to intervene while off duty, you must continue to provide care until an equal or higher medical authority assumes care of your patient. So as an EMT, let's say you're on the beach, and there's a lifeguard on the beach that's there as well, and a patient drowns, or you have a near drowning incident. Patient's pulled from the water, and the lifeguard initiates CPR. You come over, you help him with CPR, and you assume patient care because you tell him you're an EMT. Well, he may not be an EMT. He may only be an emergency medical responder. That makes you the highest level of care at the scene. If the responding unit only has emergency medical responders on it, it's your responsibility to ride in the ambulance with the patient to the hospital because you're the highest level of care. Now, if another EMT comes to the scene and takes over care, then you can hand off to an equal or greater authority, but you cannot hand off to anybody that's of less certification than you. So if a paramedic were to initiate CPR on the beach and an EMT BLS unit were to respond to the scene to transport the patient to the hospital, that paramedic would be required by law to go with that patient because they're a higher level of care. If you were to pass that patient off to somebody with less of a certification than you, then you could be found of negligence, which is a failure to provide the same care to that person with similar training. That way the patient has the best outcome possible. All four of the following factors must be present for legal doctrine of negligence to apply and for a plaintiff to prevail in a lawsuit against an EMS service or provider. Duty. It was the obligation to provide care of the provider. A breach of duty, meaning the EMT did not act within an expected and reasonable standard of care. Damages. A patient is physically or psychologically harmed in some noticeable way from their care. Causation. A cause and effect relationship between a breach of duty and the damages suffered by the patient. Abandonment is the unilateral termination of care by the EMT without the patient's consent. Basically, the EMT doesn't make any provisions for care to be continued by a medical professional who is competent to provide care for that patient. Once care is initiated, you have to assume that that patient's care is going to continue. That patient is trusting you to provide care. It's your responsibility to provide that care. Failure to perform that duty is a serious legal and ethical matter and can result in a civil action against you. Abandonment may take place at the scene or even in the emergency department where you're dropping off your patient. It's always a good idea for you to obtain a signature on your patient care record from the person accepting transfer of care at the hospital. Patient care and report given to Sarah RN and patient placed in bed T3 without incident. That's how that should be documented. So again, guys, back to documentation. You're going to find that as an EMT, you're going to spend a lot of time documenting. If you didn't document it, it didn't happen. So I can't stress how important your documentation skills are about to become. When dealing with assault and battery and kidnapping, some people get this a little bit confused and a little bit backwards and have for a really long time. When we talk about assault, it's unlawfully placing a person in fear of immediate bodily harm. That includes threatening to restrain a patient who does not want to be transported. Battery means you're unlawfully touching a person, which includes providing emergency care without consent. If the patient says, I don't want to be treated, and you stab them with a glucometer needle, that's battery. If you take that patient to the hospital without their consent and they're telling you they don't want to go, that could be construed as kidnapping. And it could include a situation where basically the patient's just flat out changed his mind and you're like, well, too late now, you're in the back of the ambulance, you're going with me. That's basically kidnapping, guys. If they're alert and oriented and refuse care, then you have to let them make their own decisions. Serious legal problems can arise in situations in which a patient has not given consent for treatment and transport. Defamation is communication of false information that damages the reputation of a person. If they write out that information, that's called libel. If it's spoken to other individuals, that's known as slander. Defamation could arise out of a false statement on a run report, inappropriate comments made on social media, or during a station house conversation. Make sure sharing war stories with friends and relatives doesn't cross the line. Be sure your run report and documentation is accurate, relevant, and factual. The Good Samaritan law protects bystanders who respond to the scene to help, as long as they're acting in the patient's best interest. A lot of times, though, EMTs don't fall under the Good Samaritan law, so be very careful. If you reasonably try to help another person, you won't be held liable for errors or omissions. The Good Samaritan conditions to be met are that you acted in good faith, without the expectation of compensation, within your scope of training, and that you didn't act in grossly negligent manner. However, again, some states don't recognize EMTs with the Good Samaritan law. You're acting under your state protocol and your state guidelines. Another group of laws grant immunity from liability to official EMS providers such as EMTs in some circumstances. These laws do not provide immunity when injury or damage is caused by gross negligence or willful misconduct. These laws are going to vary state by state, so make sure that you familiarize yourself with your state laws. You should compile a complete and accurate record of all incidents involving the sick or injured patient. Such a record is an important safeguard against legal complications. The court's perception of records and reports are, if an action or procedure was not recorded on the written report, it was not performed. There is the, if you don't document it, it didn't happen. Incomplete or untidy reports are evidence of incomplete or inexpert emergency medical care. So if you document like a moron, you're probably a moron. That's the court's view on it. So make sure that you're documenting completely, and make sure that you document everything that happened, because if you don't document it, it didn't happen. So let's say they pull your trip sheet from 5 years ago from a call that you went on that was an assault. Well, you've probably in 5 years responded to 100 assaults. How are you going to remember all the specifics of this particular assault? You're not going to. The only thing you're going to remember is what's written on that run form. So make sure, guys, your documentation has got to be spot on. Remember when I said that you have to be your patient advocate? Most states have a reporting obligation. It's your job to advocate not only for the elderly, but for children as well. We have to be the voice for those who can't speak. Most states have this reporting obligation in place, and that we're required as EMTs and EMS professionals to report child abuse, elder abuse, injury during the commission of a felony, drug-related injuries, and childbirth. These are things that we are obligated to report. We can't deliver a baby and leave it at the house and tell mom we're not going to tell anybody. It doesn't work like that. You can't pick up a drug overdose that slit his wrist and get him to sign a refusal and not report that to somebody. You can't walk into a house and see a gram of cocaine laying on the table and the patient be unconscious, unresponsive, and you not get law enforcement there to have your back in those kind of situations. In West Virginia, we have what's called the APS, or Adult Protective Services, and CPS, which is Child Protective Services, that are both available for us as well. If you suspect elder abuse, you need to report it. You have to make the phone call. I will tell you, when dealing with APS, it takes a lot to get APS to actually physically pull an adult person from the home because most times the adults are able to make their own decisions. So make sure that your documentation is spot on. If you have a patient that attempted suicide, that patient needs to go to the hospital and get professional help. Now, if law enforcement's there and the family's willing to take responsibility for that patient, a refusal could be signed. You just need to make sure you document it and you get many witnesses to sign the refusal, and you have a patient family member who is taking responsibility for that patient. Any kind of dog bite that happens has to be reported because of the outbreak of rabies. So I don't know if any of you are familiar with this or not, but in order to test a dog for rabies, they actually have to put the dog down, cut the dog's head off, and send it to Charleston to be tested. So unless the dog is actually, has only had one owner and they've got all the shot records and can prove the dog had its vaccination. So that has to be reported and followed up with. Any kind of communicable disease, tuberculosis, or anything like that has to be reported so that the health department can actively be involved in disease prevention. An assault definitely needs reported. Assaults and batteries need to be reported to law enforcement so that, these patients can feel safe and that they don't feel scared when they're in our care. Domestic violence. So I don't know if a lot of you guys have seen this or not, but online there's a big push to let people know if you see a black mark on a woman's hand, usually it's an X on her hand, that's a sign of domestic violence. If the husband wants to ride and she flashes you her hand with that X on it, then you tell them it's company policy not to allow a rider, and don't let the husband ride to the hospital with her. Tell him he has to follow so that you can get the patient by herself and get the whole story as to what's going on. So there are some things that they're working on through the system to help notify EMS personnel that there is actually an issue without us flat out trying to ask if there's an issue. A lot of times, guys, these husbands will be real overbearing, or even sometimes the wives are abusive. The significant other is real possessive. They're real overbearing, so when you ask the patient questions, the significant other feels it's their responsibility or obligation to answer the question. They'll try to ensure that you're never alone with the patient, and if they see you making any kind of direct eye contact, or at any point in time their significant other turns their back to kind of whisper something to you, they get very uneasy, very agitated very quickly. So these are some things that you can kind of watch out for on scene as kind of triggers to pay attention to. It's not uncommon that when working EMS that you're liable to end up in the courtroom. You may end up as a witness or as a defendant. The case could either be civil or criminal, and a lot of times it all falls back down to your documentation. So make sure that you properly document all of your care, all of your treatment, and make sure that you've crossed all your T's and dotted all your I's. If you are ever called to the court to testify in a proceeding, you will be issued a subpoena. If you ever receive a subpoena, you should notify your service director and legal counsel. As a witness, you must remain neutral during your testimony. You have to review the run report before your court appearance and stick to exactly what you documented. As a defendant, an attorney is required, so make sure that you have an attorney that you've gone over your case thoroughly with. If you're ever a defendant in a court case, you have to have an attorney. An attorney is required. And most of the time, your company will supply that for you with their legal counsel. Defenses may include a statute of limitations, which is the time frame in which the case must be commenced. Governmental immunity, which is generally applied to municipalities or other governmental entities. If your service is covered by immunity, it may mean that you cannot be sued at all, or that it would limit the amount of monetary judgment recovered. Contributory negligence is a legal defense that may be raised when the defendant feels that the conduct of the plaintiff somehow contributed to injuries or damages sustained by the plaintiff. Discovery is an opportunity for both sides to obtain more information to reach a better understanding of the case. There's two types of information gathering: the interrogatories, or written requests or questions, and the depositions, which are oral requests or questions. A lot of times EMS is called in for a deposition. Most cases are settled following the discovery phase during a settlement phase, and do not even go to trial. For those that do go to trial, several types of damages could potentially be awarded. Compensatory damages are intended to compensate the plaintiff for the inquiries he or she sustained. Punitive damages, on the other hand, are intended to deter the defendant from repeating the same behavior and are reserved for cases where the defendant has acted intentionally or with a reckless disregard for the safety of the public. These damages are not commonly awarded in negligence cases. In most cases, if a judgment is rendered against you, your service, or your insurance carrier, the insurance company will pay the judgment. Any EMT charged with a criminal offense should secure the services of a highly experienced criminal attorney immediately. Again, that will be typically provided by your service.